Now we will consider another contractual situation. In this set of slides, first 4 slides have already been covered. We have covered bargaining theory of contract in the first half. So the bargaining theory of contract basically says that both sides, each side should be beneficiary and should also make some sacrifice, which is to say that each side, every party to a contract should receive something, some benefit, and should incur some cost. Now, at times you will find that a contract mentions term consideration. Consideration is a technical legal term for the cost to be borne by the party concerned. In some contracts, you find that in some contracts, consideration amount of 1 rupee is mentioned. That consideration amount of 1 rupee is mentioned basically to fulfill this condition that every party should be beneficiary and should also entail some cost. For example, if I promise to, so suppose you are a friend or you are a relative or a family member. I promise you that if you pass this exam with first class, I will gift you a car, or I promise to pay for some visit to a place of your choice. This is a promise I make to you. It remains a verbal, informal promise. But we can choose to make this promise as a contract, as a formal agreement, which is to say, we can choose to make this promise a contract. Now, in this promise, what is that I offer to you? I offer you a gift of car if you pass with the first class, if you pass the bar with distinction. So I incur a cost, you gain benefit, which is car. But this logic should apply in a legal contract. This logic should apply to me also. I should also get benefit. Now, what benefit do I get by gifting you a car? I get a lot of satisfaction, joy that that you have passed, you would pass, or you have passed the bar with the distinction. But this joy or my mental state being joyful may not qualify as a consideration for a legally binding contract. But to make this contract, this promise legally binding, what you can do is you can offer me a consideration of 1 rupee, which is to say that under this contract, technically speaking, you will get benefit of a car and I will get benefit of 1 rupee. So with this added clause, our promise, our agreement can be made legally enforceable. So that is the consideration. The term consideration stands for the cost to be borne by the party concerned. Economic theory of the contract, on the other hand, argues that any promise, that is, whether it has a consideration amount or not, should be legally enforceable. In my example, where I offer to gift you a car, this agreement should be legally enforceable as long as both sides, as long as my offer was voluntary and you voluntarily accepted the offer. So as long as both sides make the offer, accept the offer, knowing fully well consequences of the offer, then such promises should be legally enforceable because they will make both parties better off. The technicality of consideration is not necessary according to economic theory, but according to bargain theory or standard legal theory of contracts, consideration is also important. Next, we are going to take example of a production contract. In a production contract, we will work with a simple example to make a larger point. We think of a buyer and seller. So suppose the buyer needs a particular kind of good, a special piece of furniture. It could be custom made. The buses have different designs, even though engine could be of Ashoka Leyland or Tata's. But if you need the superstructure of a vehicle, be it truck, be it bus, to be of special type, you will place order. You will enter into a contract with the person, with the firm, with the company that is in the business of converting chassis into buses or trucks. Take any such example where there is a buyer of a bus and there's a seller who can get chassis and turn it into a bus or truck. Suppose they decide to write agreement at date t equals 0. T equal 0 can be thought of today's date, but the delivery will take place sometime tomorrow or day after tomorrow at date t equal 2, after 2 months or after 2 years. At 0 date today, we make a contract, and according to contract, you can choose whether you want to be, in this example, you want to be a buyer or a seller. Suppose you are a seller and I am the buyer. So you and I make a contract. I promise to pay you a price for the bus, and you promise to deliver a bus that has features, that has sitting arrangements, driver cabin, as I want it. I have specified my need in the contract document, and from your side, you have mentioned the price that you are demanding for this bus to be delivered 2 months from now. So contract mentions our obligations, our entitlements, and the date of delivery. So, however, this bus is specially designed. Its interiors are specially designed. If I do not, you have prepared the interior of the bus according to my requirement, and suppose after 2 months you are ready, you would be ready to supply the bus. If I do not accept the delivery, it is an issue for you. Why? Well, if it were a standard bus, you could sell it on the market. But if the interiors are designed to meet my requirement, then other people might not be interested in buying such a bus at all. Meaning thereby, if I refuse to accept the delivery, then this bus will get you nothing in the market. Similar logic applies to interiors of any vehicle, including aircrafts. So you fear that you are seller. You fear that in the absence of a contract, if you prepare bus, if you get the bus ready, I may not. If I refuse to accept the delivery, you will incur huge losses. Therefore, you insist on a contract that mentions price. So two of us sign the contract. Now we are going to use some very simple notations. If the good is supplied by you are seller, I am buyer, then benefit to the buyer, benefit to me is going to be V. V is the value of bus in my opinion, for me. However, this bus is going to cost you something. Today, you do not know for sure what its cost is going to be. There could be several kind of uncertainty. Price of chassis might go up. So that's one source of uncertainty you face. Then you will have to buy material to raise superstructure, to erect superstructure on the chassis. You will have to hire engineers, mechanics, and a host of raw material to get the production line going. So when you sign the contract today, you are not sure what actual cost is going to be. We will denote cost by C. We know that we denote by C the cost of production for you. You are the supplier. There is an uncertainty about the cost. Cost can turn out to be very high or very low or moderate cost. You will realize that this situation, even though it's a hypothetical situation, but it arises, this situation applies to many contractual settings. Think of oil distribution companies that are in distribution of oil or LPG or CNG. They have to buy their input and supply the processed oil or distribute oil or CNGs. When these companies act as a supplier, there is uncertainty about the cost of oil for them. So cost-related uncertainty is a serious issue in many production situations for many firms in the business of service sector. So we are going to take hypothetical example. Suppose C, cost of production for you, can take 5 possible values. It's just to take a simple example. Cost could be as low as 50, or it could be as high as 235, or something in between. So these are the 5 possibilities. Each scenario is equally likely. We are making all these assumptions only in the interest of simplicity. I am the buyer. I tell you that this cost-related risk is your risk. As far as I am concerned, I will pay you a price of 170. And suppose bus is going to be worth 200 to me, and I tell you that I'm willing to pay you price of 170. I don't care what your production cost is going to be. I will pay you 170, and I want a bus, fully finished bus, after 2 months from today. So I signed with you what is called fixed price contract. From my side, the price is fixed. From your side also, price is what you will get is fixed, even though your net profit will depend on your cost. Now, in this example, this is a good example to make the point which I mentioned early on, that we may find a contract appealing when we think of a contract, when we sign the contract. But after the contract has been signed, our feelings about the contract can change. In this example, you may feel, you are in the business for decades. You have very good feel of the business, and you know that, look, most of the time cost is going to be 50 or 90. Therefore, you think 170 is a good price for you. It's a good deal. Your cost is going to be very likely 90 or below 90, and you will make a lot of money. You may feel so. If cost actually turns out to be 50, then you are even happier. But if cost turns out to be 235, then you will feel very differently about this deal, this agreement, this contract. So this is one example where you see that there's a distinction between ex ante and ex post. If cost actually turns out to be 235, you would wish that this contract is not executed. But for me, I'm buyer, I'm getting something that is worth 200 to me by paying price of 170. I do not care what the cost is going to be for you. All I care is enforcement of this contract. But you, depending on cost is 235 or 50, you may not want enforcement, or you may be very keen on enforcement of this contract. Even though in the beginning, both of us were equally keen on this contract. Ex ante, this contract we find desirable, and ex post one of us may not want this contract. Okay? So that's the distinction between ex post and ex ante and ex post. So we are going to assume that I will make the payment at the time of delivery. When you deliver the bus, that time I will make the payment of 170. It's we can change the assumption. This assumption, our conclusions will not change. It's just that we will write things differently. We will word the contract differently. But the conclusions are not going to change. Okay. Now, first of all, let's now consider if there is no contract law. You and I sign a contract here, but there is no court around to enforce our agreement. Suppose, think of this as a hypothetical situation. What will be your behavior once you learn about the cost? Remember, our assumption is when you sign the contract, you do not know what actual production cost is going to be for you. You learn about cost after signing the contract. Okay. So what once you have learned about the cost, you signed the contract with me whereby I agreed to pay you price of 170. Then you start the production and you realize what your cost is going to be. If you still go ahead at any given cost realization, if you go ahead with the production, then for the seller, your gains are going to be, you will get 170 minus cost of C that you incur in production. So this is going to be your gain. What is going to be my gain? I'm the buyer. I'm getting something that's worth 200 by paying 170. So my gain is going to be 30. Remember, in this example, my gains do not depend on what C is, because the cost related risk is all yours. So I have signed a fixed price contract with you. There are different types of contracts. There are cost plus contracts also, but I can answer the question later on. Right now, we have a fixed price contract. P is fixed at 170. So if you go ahead with production, you will get this much. This may be plus, it may be minus, but if delivery takes place, for me, I'm looking at gains of 30. On the other hand, if after looking at production cost, you decide not to produce, not to go ahead with completing the bus as per specification, then you get nothing, seller gets nothing, buyer also gets nothing. So this is the simple situation. I want this contract to be performed, to be enforced, but there is no court around. I am at your mercy. You would want, now you will decide. Question is, what will you do if cost turns out to be 175? If you are looking at cost of 170 and price is if you are looking at cost of 175, but price is 170, you clearly would not want to undertake production. You will not produce the bus and you will not supply it, because if you did so, it would mean a loss of 5. On the other hand, if cost turns out to be 90, then surely you would want to go ahead with production. You will supply the bus, you will get 170, and both of us will be happy. Okay, there's a question by Gitanjali. Gitanjali, ask the question.
Yes, sir. Thank you. Sir, my question is, you have stated that if contract fail from buyers, and then all the costs will be bear by a seller in case of in case if buyer refuse to accept the outcome. But what if a seller could not fulfill its promise, its delivery on time? Then what are the rights associated with buyers?
We will come to that, Gitanjali. It's a good question. We will come to that. At the moment, we are thinking of a situation where there's no court around to enforce this contract. So therefore, whether you renege or I renege, court can't do nothing because there's no court around. We will come to answer your questions shortly.
Thank you.
At the moment, I want you to think, you know, think of a situation where the cost, your supplier, your cost is 175, and you will not supply the bus, because if you supply the bus, it is you are looking at a loss. I want to now bring in idea of efficiency. So if cost is 175, I repeat, if cost is 175, it is not in supplier's interest to supply, because the supplier will make losses. But what will efficiency demand? What is the requirement of economic efficiency in such a situation? Can somebody tell? Let me give you the answers. From when we look at social efficiency, or what is called Kaldor-Hicks efficiency, we do not look at who will gain what. What we look at two things. What is going to be the total cost, and what are going to be total benefits. In this example, if cost of bus is going to be 175, then the social cost, then bus as a good, its social cost is 175. What are the social benefits? Social benefits are benefits to the buyer. Buyer will get benefit of 200 because buyer thinks this bus is worth 200. The social benefit, which is 200, is greater than cost, which is 175. Benefit greater than cost. Therefore, social efficiency demands that bus production should take place. In this situation, but the supplier doesn't care about social efficiency. Supplier cares about her benefits. In this case, her benefits are going to be less than 0. She is going to make a loss of 5. So in this example, you can see there's a conflict. There can be conflict between social efficiency and individual interest. Even though it is socially efficient to produce bus, even though it's going to cost 175, but it is not in the interest of supplier. So she is not going to supply the bus. That will be an inefficient decision from social viewpoint. Other way of, if you are interested in finding out whether something is socially efficient or not, instead of assuming that there are buyers and sellers are two different individuals, assume that they are same entity. Assume that you are supplier, and you need to you need to manufacture a bus for your own use. For your own use, suppose the benefits are again going to be 200. You will, in that case, you will manufacture this bus, even though it's going to cost 175. It's going to cost you 175, but you are looking at benefits of 200. Therefore, you will go ahead, manufacture bus and use it. That will be socially efficient decision. So the divergence between social efficiency and individual interest arises because people are different. Different people have a different interest. If there were only one person around, all her decisions will be socially efficient. In this case, our supplier will not go ahead with production if she has to sell this bus, supply this bus at a price of 170. That, I hope this point is clear. So from social efficiency, the social efficiency does not look at your profit, supplier's profit. Social efficiency looks at whether C is less than V or not, whether construction cost is less than 200 or not. Okay, that's one point. Now coming to the question that Gitanjali asked, what are what if the supplier refuses to supply or buyer refuses to accept the delivery? Okay. First, consider the case where supplier refuses to supply. We bring in contract law and courts to execute the contract. Now think of there's a court around, and that court will apply contract law if the supplier refuses to supply. We can also talk about what happens if the buyer refuses to accept the supply. But first consider the case where supplier refuses to supply. Then if supplier refuses to supply, court can, let's start from the reverse order. Court can issue specific performance order, meaning thereby directing the supplier to supply the bus as specified in the contract document. If court issued such an order, it will be called specific performance directed by the court. The remedy, legal remedy, will be called of specific performance. It is similar to legal remedy of injunction in the context of property law. But in contract, where court gives specific direction to act according to terms of the contract, then that remedy is called specific performance. Instead of telling the supplier to supply bus as specified in the contract, court could look at contract document carefully to find out if the two parties, when they sign the contract, if they have talked about situation where supplier may not supply. In this example, you are supplier, I am buyer. When two of us sign the contract, it is possible that we mention in the contract that your obligation as a supplier is to supply the bus with specifications mentioned herein at a price of 170. And contract may say that if supplier does not supply, she will have to pay, make a payment, or compensatory payment, or make a payment of, let's say, 20 or 30 rupees to the buyer. If contract itself specifies what compensation, what will be paid by supplier to the buyer if supplier refuses supply, that remedy is called liquidated damages. The damages, whenever you see the word damage, so damage without s in legal terms, it means harm. That's what it's according to its literal meaning. But when you read the word damages, damages does not mean plural of harm. It generally it means compensation. So a court may see if contract itself provides for compensation. If contract itself provides for compensation, courts generally apply that. And we say that courts have applied liquidated damages, which is the compensation mentioned in the contract itself by the contracting parties. So that's situation 2. In most situations, however, court will, if you do not supply, I go to court saying that, she did not supply as promised. As a result, I have suffered from loss. Compensate me. I will request the court. And court can then decide to compensate me based on 3 principles. First principle, or first rule that court can adopt, is called expectation damages. Second is restitution damages or reliance damages. We will consider these damages. Damages, remember, stands for compensation. So we are going to use a notation. Our notation would be D. D will stand for, D is symbol we use for damages. Damages stands for compensation. A damages measure is a rule that specifies what compensation buyer will get. If supplier refuses to supply, then buyer becomes the victim of contract reneging by the supplier. So a damages measure a damages measure specifies the entitlement of the victim of breach of the contract. So damages measure. We denote D by damages that court or the contract law specifies. So it means that if you as a supplier do not supply the bus, and court will tell you to pay me amount, that amount is denoted by D. D as in damages. So D as in damages, it can depend on several characteristics of the contract, but we will consider simple cases. Suppose court says that you have to pay 30. If you do not supply the bus, court orders you to pay me 30. In other words, court chooses D equal 30. We will now consider, so under this law, under this damages law, we will now study your behavior. Remember, a few minutes ago, I had argued that if C, your cost turn out to be 75, social efficiency demands that you produce and supply the bus. You remember this inference? But if there is no contract law, you will not supply the bus because it will be a loss-making decision for you. We are going to check now your decision if there's a contract law that fixes D equal 30 in this case. So now consider the situation that D is going to be 30. What will you do? Your cost turns out to be, suppose, 175. Prices as before 170. If you supply me a bus at a price of 170, you will get 170, I pay you 170, but your cost is 175. Therefore, you are going to make a loss of 5. You don't want to make a loss, but what are the choices available to you? Choices that you renege on your promise. If you renege on your promise, then you supply me no bus, I pay you nothing, but you get nothing from me. On top of it, you are obliged to, a court is going to direct you to pay me 30. So what are you are looking at? You are looking at a cost of 5 by way of loss if you supply the bus, or a cost of 30 if you do not supply the bus. So both are bad situations, but this situation, not supplying the bus, is worse than supplying the bus. So now, in your interest, you will choose to supply the bus. Cost is 175, less than the price you will receive, still you will produce and supply the bus. And social efficiency demands you to supply the bus because the cost is less than social benefit from the bus. So if D is fixed at 30, then your decision is going to be efficient. You really, I don't need to persuade you to agree with me that if cost turns out to be 50 or 90, you surely will supply the bus. But if the cost turns out to be higher, let's say 225, you will not supply the bus, even if there is a penalty of 30. I leave it to you. And actually, here is the argument. So suppose your cost turns out to be unusually high. A conflict has broken out somewhere where you get your supply of your inputs. As a result, prices have gone through the roof. In that situation, you now are asking, should you still go ahead with production and supply the bus? If you do that, you will get 170 from me, but your cost is going to be 225, so you are looking at a loss of 55. On the other hand, if you do not supply the bus, you will have to pay me 30, but 30 is less than 55. So now your decision will be to renege and make the payment. That is better than supplying the bus. That's going to cost you 55. So you can check that if D is 30, then if D is 30, then you will supply the bus as long as cost is less than 200. You will not supply the bus if cost turns out to be more than 200, which is if it turns out to be 220 or 235. Now you may see that, at this point you may want to ask, if there's anything special about number 30. Why did I choose 30? 30 was chosen deliberately. It was not accidental random choice. It was a deliberate choice by me. 30 happens to be equal to 200 minus 170. What is 200? 200 is value of the bus for you. What is 170 is the contract price. So D, I had chosen D deliberately to be equal to V minus P. Whenever a court chooses D, that is equal to value of the good to the buyer minus the contract price, the court will choose damages that will give efficient incentive to the supplier. Other way of looking at D equal V minus P is expectation damages. So if you look at things from my viewpoint, I'm a buyer. What am I expecting from this deal, from this contract? I have to pay 150, but I'm expecting to get something that is worth 200 to me by paying price 170. So my expectation from this contract is a net benefit of 30. So my expectation is of 30 from this deal. If a court is going to give me 30 when you do not supply the bus, then court has fulfilled my expectation. Court has provided me compensation that is equal to my expectation from the contract. And therefore, this amount will be called expectation damages. Compensation that fulfills my expectation. So D equal V minus P is expectation damages. If courts apply expectation damages, then my expectation, I do not care whether you supply the bus or not, because if you supply the bus, I'm looking at net benefit of 30. If you do not supply the bus, then again I'm looking at net benefit of 30 by way of compensation. So I am indifferent whether you renege or you fulfill the contract. My expectation has been fulfilled. That's why it is called expectation damages. D equal V minus P is called expectation damages. And we have seen that if a court applies D expectation damages, then you will produce, if cost is 50 or 90 or 175, you will not produce if cost turns out to be 220 or 230. In that case, you would rather compensate me directly. Remember, D, V minus P depends on V and also P. So it will change if the expectation damages will change if instead of if the contract price was 160 instead of 170. If contract price was 160, then D would become, expectation damages would become 200 minus 160, it will become 40. So expectation damages depends on the contract price. That's the idea of expectation damages. Any questions? All right. If not, so you can read these bullet points later on. I have explained. So under expectation damages, the reference point is what the buyer is hoping to get from the contract.
Professor, there is no impact of time cost?
Time cost in what sense? The delays?
So I get my expectation damage of 30, but that happens after
You mean,
duration.
are you referring to judicial delays?
Yes, yes.
Right. So in this simple example, we are assuming there are no judicial delays. It's an unrealistic assumption, but that is what we are assuming. If you
All right.
think if there are judicial delays, then if you are going to get 30 after struggle of 2 years or 10 years, then 30 will not be like 30, it may be just 3. And in that case, we would say your expectation is not fulfilled.
Yes, sir. Thank you.
So in that case, your argument, your question again reminds me of penalties. If there are judicial delays, then to compensate you, to fulfill your expectation, either court should give you compensation of 30 immediately the day you report breach of contract, or if court is going to give you compensation after 2 years or 20 years, then court should compensate you for the time cost. So the compensation should be 30 plus time cost. Then only your expectation will be fulfilled. So to make the basic points, here I'm not assuming, I'm assuming enforcement cost to be 0. It's unrealistic assumption, but to make a point, that's what I'm assuming. I felt somebody was trying to ask a question and then, but I could not hear what the question was.
Like expectation damages is less than 30, and similar like what madam was telling, like if you add enforcement cost more than 30, that also scenario just like I was thinking, I don't, but I think you answered that, sir.
Okay, all right. Now expectation damages, according to some legal scholars, expectation damages are too high. Basically you want to fulfill the expectation of the buyer, that may require not only compensating by amount of 30, but also by compensating the litigation cost of the buyer, and also compensating her for the time cost and other discomfort that she undergoes in the litigation. So there is a set of scholars who feel that expectation damages are too high. In some legal orders, expectation damages are not used. Instead, reliance damages are used. So what is the reliance damage? So to understand reliance damages, we have to understand the legal notion of reliance. Reliance is the set of things the promisee does. Promisee in our example, promisor is the supplier who has promised, the promisor supplier has promised to supply the bus 2 months from the date of contracting. Promisee is the person who has accepted the promise. So the buyer in this case, in our example, is the promisee. Now the buyer, promisee, he or she may do things relying on the promise made by the promisor. For example, so I am the buyer and I believe that you will supply the bus 2 months from now, and I may be a bus operator, a transport operator. I may start accepting booking, relying, believing that you will compensate, you will supply the bus. So such things, my accepting booking, or my getting the painting, number plates, etc. done, hoping that I will have bus on 60th, 61st day from the date of contract. All such expenditure activities are treated as reliance actions on the part of promising the buyer. Why do I do such things? Well, I can, so I can use the bus by accepting bookings beforehand, by painting it in the color of my choice, and things like that. So the utility of the bus goes up for me, if I do these things. In other words, what I'm trying to say is that I told you that bus is worth 200 to me, but in reality, bus will become worth 200 to me. It will deliver benefit of 200 only if I spend 20 extra on it, by accepting prior booking, by hiring painters, um, making them down payment. So if I believe that you will be supplying the bus, I may incur expenses of 20, thinking that 61st day there'll be bus, and I have already spent 20 to get the finishing of the bus done, so that it's ready to use on 61st day itself, on the day of delivery itself. If you delay, if you do not supply the bus, then my 20 goes waste. All these expenses, the bookings I have done, I can't fulfill those. So I have to compensate for the promise that I had made to other people. If you do not supply, if the supplier does not supply, then I lose my 20. Court may say that, a court may say that, look, I'm not going to compensate you by 30. 30 is what? V minus P. Court may say that, look, your loss is only 20. So I will compensate you. A judge may say that your compensation will be 20. 20 is the reliance expenditure. I have the amount I have spent relying on your promise. So if a court adopts such an approach, such a reasoning, we will say court has adopted reliance damages, or court is compensating me according to formula of reliance damages. So under reliance damages, I will get only 20. If I get 20, then we have to ask the question. There is a question for you. If cost turns out to be 175, and judge, you know that judge will apply rule of reliance damages, will you produce the bus? Before you answer this question, I want to help you remember that under expectation damages, you will produce the bus even if it's going to cost you 175. Even if it's going to cost you 175, which is greater than price, you will still go ahead and deliver the bus under expectation damages. What was expectation damages? 30. But if we change the contract rule is that compensation will be compensation will be 20. What will you do? Will you still produce and supply the bus? You will not supply the bus. Dhruv is absolutely right, because if you supply the bus, you will make a loss of 5. But if you oh, I'm sorry. If you make a if you supply the bus, you will make a loss of 175. So you will make a loss of 5. You will get 170 from me, but bus will cost you 175. So your loss will be 5. But if you refuse to supply the bus, then you will have to pay me 20. It means that your loss will be of 20. So your loss is less if you produce and supply the bus. You will go ahead, produce and supply the bus. We will reach at same outcome as under expectation damages, even though the different contract rule has been applied, but same conclusion will be arrived. You will still produce and supply the bus. Now, those of you who feel that you have understood today's lecture, I want to give you simple exercise, simple but interesting exercise. Listen to the question carefully. If suppose we we assume that contract price is P equal 125. If contracted bus price is 125, you will get different conclusion under expectation damages and the reliance damages if contract price is 125. When you start finding out what supplier will do under expectation damages with contract price 125, you have to remember that under expectation damages, the formula is D equal V minus P. Under expectation damages, V equal V minus P. P we are assuming to be 200. P we worked with P of 175. So 200 minus 170 meant D was 30. But if we change contract price from 170 to 125, then expectation damages will also change. If we reduce contract price from 170 to 125, D will increase from 30 to 75. So at a price of 125, expectation damages will be 75. Why will it be 170? Why it will be 75? Remember, I am expecting bus worth 200 to me by paying price of 125. So I am expecting net gains of 75, 200 minus 125. So therefore, to fulfill my expectation, court will have to pay me, court will have to ask you to pay me 75. But the conclusion will not change. What we talked about that under expectation damages, you will not produce if cost turns out to be 220 or 235. You will not produce the bus if your cost turns out to be 220 or 235. This conclusion is independent. It does not depend on what contract price is. This is what I want you to check. When cost is 220 or 235, you will choose not to supply the bus. It doesn't matter what the contract price is. On the other hand, you will choose to supply the bus if cost turns out to be 50 or 90 or 175. This conclusion does not depend on what contract price is. Take it as a simple exercise, prove it later on. However, so that is what we see. However, under reliance damages, the compensation is going to be 20 regardless of the contract price. But your decision to supply is going to depend on the cost as well as contract price. So you are going to get at different outcomes under reliance damages and under expectation damages. Expectation damages are socially efficient, reliance damages are not. Why reliance damages are not? Take the example. Suppose contract price is 125 and your cost turns out to be 175. So if you supply the bus, you are looking at a loss of 50. On the other hand, if you choose not to supply, then you have to pay me just 20. So in such a situation, your losses are less if you do not supply. Cost is 175, you will choose not to supply. But this is socially inefficient decision. Why is it socially inefficient decision? Remember, the social efficiency does not look at what the prices are, who gets what. Social efficiency looks at total gains and total cost. What are the total gains? Total gains are 200, a bus worth 200 to somebody. What are the cost? The bus that cost 175 to somebody. Social efficiency does not care who will bear the cost, who will get the benefit. Social efficiency looks at the social benefits versus social cost. Who will bear these costs and benefits are not something that affects social efficiency. So we have seen here Reliance damage is not socially efficient. The third leading measure of compensation under contract law is called restitution damages. Under restitution damages, there is no compensation of any sort, except that if people have made payments, if one party has made payment to the other party, those payments have to be returned back. In our example, we assume that the payment, the buyer will pay the supplier at the time of delivery. Therefore, the restitution damages will be zero because buyer had paid nothing to the seller. However, if the buyer had made some down payment, then down payment will be returned back to the buyer. So in any situation when you find that one party, the buyer had made a down payment to the seller and seller did not supply, seller refused to supply but returned the down payment, or court asked the seller to return the down payment. In those situations, it is as if restitution damages have been applied, meaning thereby whatever was paid to the other side, that amount, that thing gets restituted. That's why the term restitution. Under restitution, also the outcome is not going to be socially efficient. It is easy to see because under restitution damages, the supplier has to pay no penalty of any type. Therefore, supplier will compare the price and the cost. And if cost is 175, price is less than 175, supplier is not going to supply. That will be inefficient decision. Remember, when we said that when cost is 175, social efficiency demands supply, we didn't ask what the price is. Role of price. What is the role of price in any transaction, contractual or any market transaction? Role of price is to distribute the gains from exchange between the parties to the exchange. Role of price is the trade, any trade or any exchange, it generates social gains. It generates social surplus. Role of price is to distribute that surplus, those gains between the contracting parties or trading parties. That's the only role of price. And social efficiency does not factor in the price. Remember, individual gains and losses are not what derive social efficiency. So prices do not affect the recommendation or requirement of social efficiency. But under reliance damages and also under restitution damages, prices will determine behavior of the supplier. As a result, behavior of supplier is not going to be socially efficient generally. So to sum up the discussion, we can say that expectation damages are efficient, reliance damages are not efficient. Restitution damages are also not efficient. I have put out some questions for you to try to check your understanding. So let me take questions. Questions, please.
So this 30, which is different between net value versus if we see from the social welfare point of view, if this 30 was not there, whether still you want to consider that expected damages are efficient. If it was 20, yeah, it was something less than, yeah, something else amount then.
It can be anything. The requirement is that D should be equal to V minus P. That's the test. If D is equal to V minus P, we say that D is expectation damages, because the buyer is expecting V, a bus that is worth V to him, by paying price P. The difference between the two is what the buyer, the benefits that buyer is looking at. So whenever D is equal to V minus P, whatever we have said will be true. Now D can be 30. So if P is 170, because 200 minus 170 is 30. D can be 70 also if the price is 130. If contract price was 130, then D will have to be 70. So when a court applies expectation damages, it can't say that pay this much amount. Court will have to look at the benefits that the buyer is expecting, promisee is expecting. Court will also have to look at the price that the buyer was willing to pay. The difference between the two would determine expected benefit for the buyer, and therefore will determine expectation damages. You change V or P, then D will change. So to implement expectation damages, a court implementing expectation damages is not easy thing, because the benefit of a good or service to the buyer is what only buyer knows. And when litigation happens, buyer will have incentive to exaggerate these benefits. Buyer would say, oh, I would have, this bus or this good was meant so much to me, so it was really valuable to me. Buyer will have tendency to inflate V, but because by increasing V, D will increase. And court would have no way to verify, to find out what true V is. On the other hand, under reliance damages, court has to assess the expenditure, the amount that promises spent, because promisee relied on the promise, relied on the contract. So, again, going back to your and Professor Nagar's question about enforcement cost. Even though our conclusion is expectation damages are more efficient than reliance damages, but if we factor in enforcement adjudication cost, then our conclusion can change, because adjudicating expectation damages is by no means it's easy for any judge. No judge would know what V is, what the benefit buyer would have enjoyed if delivery had taken place. On the other hand, court can ask the question, what did you spend relying on that promise? And court can then compensate the promisee for the expenses that the promisee undertook, because promisee relied on the promise in the contract. So enforcement of reliance damages is easier, because expenditure can be verified. Utility cannot be verified. Utility, V is a utility of the good or service to the buyer. Utility cannot be verified. Therefore, expectation damages enforced adjudication is very difficult.
So
there are
Reliance is
trade-offs.
efficient compared to expectation damages. Sorry.
So if we bring in adjudication cost, then Reliance damages are more easier to execute and can turn out to be more efficient also.
So similar like streak versus negligence like thing.
Right. That is why, either courts tend to rely on Reliance damages or on specific performance. Going back to the legal remedies we discussed. Legal remedy of expectation damages is ideally, in theory, it is efficient, but it is hard to execute. Reliance damages, in theory, is not as efficient, but it is easier to execute. What is best is the it's best if courts implement remedies or compensation formula or amount that parties themselves have specified in the contract. So wherever contract itself specifies the compensation for non-performance, then that is best that courts should use. Courts should, in my view, courts should have minimum interference with the contract. Courts should come in with restitution, reliance, or expectation damages only if contract does not specify the liquidated damages. Or court can also think of specific performance wherever courts know that the cost to the supplier are not going to be exorbitant, are not going to be economically ruinous for the supplier. I guess we can, if there are questions, or we can take a break. We can call the session off.
Any question? If there, then we can take 1 or 2 questions and then we'll have a 5 break post. Anybody's having any question?
I think we are dealing with a highly satisfied lot, and we can.
Professor, with regard to the delays as far as contractual disputes are concerned,
Yes, I'm listening, Professor Nagar.
And maybe in a comparative sense with other jurisdictions in terms of the law, the contract law, which are these aspects, which we learn insights from the law and economics literature? What would you suggest that within many things that can be done, what is that one thing that Indian processes are maybe not doing very well pertaining to the learnings from the economic analysis of contract?
Okay, so in my view, Indian courts do not show enough appreciation for economic consequences of different contract terms and different contract rules. Actually, they seem to be not realizing the importance of the contract itself. Your question reminds me of several incidents. One incident, one set of incidents relates to the procurement, the contracts between companies, private construction companies that build highways or state highways or bridges and collect toll. There are toll contracts that companies sign with the government. At times it happens that, so think of a situation where you as a company, you build a road or bridge, and state government gives you rights to collect toll from road users. Now your benefit are a risky proposition your benefit from such an obligation, such an undertaking, will depend on construction cost, road construction cost, bridge construction cost. They will also depend on the traffic that the road segment will attract tomorrow in future. As a result, there is a lot of uncertainty about the profit that these companies will make. At times, in several occasions, it has happened that the traffic turned out to be much greater than the traffic that was expected when contract was signed by a private company and the state government. For example, Delhi-Noida toll road is one example where the construction company had expected some traffic, but actual traffic turned out to be much higher. As a result, toll revenue, the money that company made, turned out to be greater than the company had expected. Road users went to first district court and then Allahabad High Court, saying that this company has already made a lot of money charging toll from road users. Therefore, the appeal of road users was to stop the company from collecting toll. Company, on the other hand, construction company, on the other hand, argued that, look, this is our contractual right. We have fulfilled our contractual obligation by building a road, by maintaining it. We have met all the expenses. We have fulfilled our contractual obligation. So do not change our contractual rights. This was the nature of dispute. The Allahabad High Court ruled in terms in favor of road users and stopped the company from collecting the toll. Now, if we look at such judgments, they may look plausible and social welfare enhancing judgments because they protect interest of lakhs of road users versus selfish interest of one private company. This is how courts have looked at such matters, and this is how several commentators in media also welcomed the judgment. But my view is different. If we look at in economic analysis and courts, they should look at the consequences, future consequences of their actions, their decisions. In this particular matter, lakhs of road users have benefited, but there's a cost associated with such judgments. Such judgments make the contracts risky for the firms that invest money in projects, because such a judgment means that companies will feel that in future, whenever there's an upside for them, whenever it's their turn to bear the loss, then courts will not come to their rescue. But when they are making profits, then courts can come in and stop that profit-making process. In such a situation, there'll be few investors who would want to come forward and invest in risky infrastructures. And those who come forward to invest would demand higher premium, maybe would demand annuity or upfront payment from the government. As a result, the funding of infrastructure will suffer, and courts don't seem to appreciate such consequences. Other example, I can cite several examples. So about 2-3 years ago, pollution. Pollution is a serious problem in National Capital Region of Delhi. So, and pollution becomes especially acute during Diwali. People use firecrackers, that adds to pollution. It's a serious issue, and public authorities, government agencies, and courts should do something about it. But what Supreme Court of India did is, if you think of any supply chain for any good has to be produced somewhere, then it has to be transported to different cities and villages, then it gets stored by wholesalers or by retailers, and then wholesalers sell the good to retailers in turn sell the good to consumers. So the supply chain is a long supply chain. Same logic applies to firecrackers. Firecrackers are produced, manufactured in Tamil Nadu, in UP, then transported to different parts of the country. They are stored through the year and then sold to retailers around Diwali. Retailers in turn sell the firecrackers to users. What Supreme Court did was very interesting. Supreme Court did not make manufacturing of firecrackers illegal. That was kept legal. The court did not make it illegal to transport firecrackers from point A to point B. That was legal. It also did not make it illegal to store them. It also did not make it illegal to sell firecrackers to, it also did not make illegal any contracts between producers and wholesalers and retailers. It only imposed ban on the final sale by retailer to consumers. That too at a short notice near Diwali. People, who had signed, wholesalers had signed contract with producers. They had invested a lot of amount in production and also in reliance. And all that was not made illegal, was not stopped by court. Court simply banned the sale of firecrackers. The outcome was what you would expect, that firecrackers were burnt with the intensity as before. Because people had invested already so much in supplying, and with some illegality, they were able to sell the firecrackers to individual people, users. So such instances, I can cite several such instances, but they show that, the courts need to be, it will help if courts show greater appreciation of the supply chains, the type of contracts that get signed, the incentives different contracts generate for the parties involved. So these are the concerns. Hopefully we are moving in the right direction. Hopefully we will have judges who are more appreciative of economic analysis.
Thank you. But sir, a bit more trouble, effort for you. There are a few questions in the chat box, please.
Okay, sure. Let me take the questions. What are these? Can somebody, do you want to? So, sir, but the specific performance recently made as a default remedy, how much such discretion is available to courts to provide damages? And I do not think specific performance is a default remedy. No, it depends on the situation. Courts generally do not take specific performance as a default remedy. Courts use compensation remedy as a default only in specific cases where the promisee can argue that the performance is important. No amount of compensation is good enough. Only in those special cases, courts insist on specific performance. But generally, courts are open to providing compensation as a remedy for contractual breach. Then Adya has asked a question, from a welfare economics perspective, how do we measure efficiency of contracts where one party is disproportionately wealthier than the other? You see, the social efficiency, unfortunately or fortunately, it does not look at wealth level of individuals involved. It also does not, the social efficiency looks at only the social cost and social benefits of a particular set of actions. The social efficiency will ask the question, what are the net social gains generated by a contract? If a contract is going to deliver a bus worth 200 by a cost of 170, contract is, the social efficiency is blind to the identity of individuals involved. The individuals could be wealthy, one side could be very super wealthy, other side could be super rich, super poor, ultra poor. Unfortunately, the social efficiency is blind to these issues. Social efficiency is also blind to the price. Ideally, you may feel that, if one of the contracting party is poor, then the contract price should be decided keeping in mind wealth level, economic status of two sides. No, social efficiency does not do so. If I am not saying that we should not consider such issues, but the way social efficiency is defined in welfare economics, it does not look into these aspects. If you want to look into these aspects, then we have to go beyond standard efficiency, social efficiency, as it is conceptualized in welfare economics. Then I think there are questions related to externalities generated by contracts. For example, contracts signed by gig worker, like those who work for Swiggy, Zomato, Uber. The company is a regular party to such contracts, but there are areas where it has lesser liability than of the workers. Yes, these issues actually arise. The changes in the contracts that these companies are signing, they are adversely affecting the contracting parties. But as I said, that social efficiency does not look into economic efficiency, does not look into the gains from distribution of gains from contracts. It looks at whether the contract itself is going to promote net social gains or not. That is what it does. These questions underscore the need to have a perspective that is more wholesome than confining itself to economic efficiency. Economic efficiency is a good guide in several situations, but it can't be the only guiding principle. Let us stop here. We are 1 minute past 6 o'clock. It's time for the next session.